Green check 2. Green check 2.
people can join us as they join us. So let's go ahead and go on the record. This is file number WX-2025-0032 in the matter of the proposed rescission of the Commission's Rule 20 CSR 4240-50.050 and file number WX-2025-0033 in the matter of the proposed rescission of the Commission's Rule 20 CSR 4240-10.095. My name is Nancy DePel. I'm the Regulatory Law Judge presiding over this rulemaking hearing today. It's 10 a.m. and we are in the Governor Office building. We set this time for a rule comment hearing on the two rules that I mentioned, and rulemaking hearings are a little different than our regular evidentiary hearings, so we don't have sworn testimony. Instead, anyone is able to comment if they wish, and therefore it doesn't matter if you're an attorney and representing a company, or a company doesn't have to be represented by an attorney. So there have been some written comments filed, and we are doing both of the rules at the same time. So I will ask for your oral comments, and I just ask that you be clear which rule you're commenting on when you're doing so. I have with me on the bench today Chair Hahn, and I'm expecting online some of the other commissioners, so they may interrupt as they join in to let us know that they're present. Do we have any questions before we get started? Okay. Just go ahead then, and I'm going to let staff go last, unless you want to go first.
Have you go first.
Well, just go ahead and go first then. I will give each of you an opportunity to respond if there are comments. We want to get everything on the record that we need.
All right,
Go ahead.
absolutely. Thank you, Judge. Good morning, Chair Hahn and any other commissioners online. I'm Mark Johnson. I'm counsel for staff. I have with me today Curtis Gately, who's the manager of the Water, Sewer, Steam, and Gas Department, and he's here to answer any questions if you may have any. But I'll just go ahead and jump right in. We have filed comments in the docket already, so I will keep my statement short, but I will also provide a brief response to the written comments filed by the Office of OPC. So first up, I will address docket number WX-2025-0032 relating to the rescission of 20 CSR 4240-50.050 environmental cost adjustment mechanism. As stated in staff's pre-filed comments in this matter, staff supports the rescission of this regulation. Now, the Commission's ECAM regulations arose from the passage of Section 386.266 of the revised statutes of Missouri. That legislation allows electric, gas, and water corporations to request from the Commission authorization for certain types of rate adjustment mechanisms, specifically a revenue stabilization mechanism, and then, of course, the environmental cost adjustment mechanism. Specific to the topic of this hearing, the legislation authorizes a water corporation to make an application to the Commission to approve rate schedules authorizing periodic rate adjustments outside of general rate proceedings to reflect increases and decreases in its prudently incurred costs to comply with any federal, state, or local. Subsection 10 of that statute provides the Commission with rulemaking authority to promulgate rules to govern the structure, content, and operation of such rate adjustments, and the procedure for the submission, frequency, examination, hearing, and approval of such rate adjustments. Further, Subsection 13 requires the commission to have previously promulgated rules to implement the application process for rate adjustment mechanisms detailed in 386-266 prior to the commission issuing an order for such rate adjustment mechanisms. So, given that information, why is staff supportive of rescinding the ECAM regulations? Well, simply put, it's because this regulation has never been utilized in the 11 years it's been on the books. The Office of Public Counsel has filed comments opposing the rescission of this rule, stating that the rule provides important uniform procedural requirements beyond those provided in statute, and contends that without it, the Commission would lack authority to authorize an ECAM. Now, staff agrees the regulation does provide uniform procedural requirements that are above and beyond what's included in the statute. However, staff does not agree the Commission would lack authority without the regulations. Now, in OPC's pre-filed comments, they cited to subsection 13 of 386-266, and I would point out, as I stated earlier, that that section only states that the Commission must implement rules for an application process prior to any order for these rate adjustment mechanisms. And I would point to the fact that the Commission has general requirements for applications before it in Chapter 2 of its rules, specifically 20 CSR 4240-2.060. Staff believes these regulations provide an adequate pathway for a water utility to request an ECAM in the future if it should wish to, and any guidance on the process for necessary reviews, such as an annual true-up or prudence reviews, could be detailed in the water utilities tariff creating such a mechanism. And that could be dealt with in the case file relating to that mechanism. But that being said, staff is not opposed to keeping the rules in the Commission's statute or in the Commission's regulations if the Commission would choose to do so. However, I would point out that, as I said, it is yet to be utilized in the last 11 years. If the regulation was kept on the books, staff is not confident it would be used in the future. Moving on to WX-2025-0030 relating to the rescission of 20 CSR 4240-10.095 environmental improvement contingency funds. I would state that, again, as stated in staff's pre-filed comments, it supports the rescission of this rule. A little background on this one. This rule authorizes water or sewer utilities that serve fewer than 8,000 customers to establish an environmental improvement contingency fund. Now, in short, the EICF allows a small water or sewer company to collect revenue from its customers to go towards necessary improvements directly related to state and/or federal environmental health or safety requirements prior to those improvements going into service. The reasoning for this mechanism is that it can sometimes be difficult for a small water or sewer utility to obtain sufficient capital for investments. The fund would allow these utilities to collect revenue from customers over time to fund those projects instead or in addition to financing utilized to fund those improvements. Now, while the rule has a noble goal, the reality has been that this regulation is simply not utilized. In recent years, the cost to complete capital improvements has increased greatly, making it difficult to collect sufficient additional revenue in a reasonable amount of time to satisfy new environmental requirements. Additionally, these funds must be closely monitored by the utility and the PSC staff to ensure there's no misuse or commingling of customer revenues. The administrative burden has proven to be difficult for these very small and oftentimes unsophisticated companies that would be helped most by the use of the EICF. In the 6 years the regulation has been active, only one utility has requested the use of an EICF, and it no longer utilizes the fund. So therefore, staff, as stated before, supports the rescission of Commission Rule 20 CSR 4240-10.095. Thank you. I'm happy to answer any questions you might have.
Thank you. Are there any commission questions? Chair Hunt? All right. Anyone online? Not hearing any. Thank you, Mr. Johnson.
Thank you.
Are there comments from public counsel?
Yes, just briefly, Judge, thank you. Good morning, Judge DePel, Chair Hahn, any commissioners who may be online. The OPC just wants to take this time to
Would you go ahead and give us your name and
apologize.
stuff for the record? That's all right.
Yes. My name is Lindsay Van Gerpen, and I'm appearing on behalf of the Office of the Public Counsel. We did file written comments in the WX-2025-0033 case concerning the environmental cost adjustment mechanism. So I'm happy to answer any questions on that rule. I did want to just briefly respond to staff's point about the application process and the necessity of the rule. So the OPC has opposed the rescission of that rule on the grounds that the rule itself does include additional procedural requirements above what's included in the statute. And as the way that we interpret subsection 13 is that the commission does have to would have had to previously promulgate a rule prior to approving an environmental cost adjustment mechanism. And our understanding of that provision is supported by the Western District's decision in State XREL, Office of Public Counsel v. Mo PSC at 331 Southwest 3D 677. And that is a case that considered the environmental cost adjustment mechanism for an electric utility in 2011. And in that case, the Western District stated that subsection 12, of the statute, which later became subsection 13, plainly and unambiguously requires the PSC to promulgate the ECRM rules prior to issuing an order for an ECRM rate adjustment, not prior to January 1, 2006, and therefore statutory construction was unnecessary under the court's analysis. So our position is mainly that because the commission has to promulgate rules prior to issuing an order, and this rule has previously been promulgated, we would oppose rescission of that rule, and that's our position. We have not filed any comments and take no position on the rescission of the rule for the environmental cost, the ECIF, in WX 2025-0033. I'm happy to answer any questions.
Thank you. Chair Hahn?
Unrelated to the current hearing we're in right now, are you the DCI employee of the quarter for OPC?
I was, yes.
Congratulations.
Thank you very much.
Are there any other commission questions? Not hearing any. Thank you.
Thank you.
Is there anyone else present that would like to give comments? All right, I believe then that concludes the comments for this rulemaking hearing, and we can go off the record. Thank you.